About to leave, already packing. Come with me, I'm not really asking. We'll get away to a place where we don't know. About to see the world in action, what we can be, life with no distractions. We'll get away, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free with me. Let's go. Let's be free with me. Be free. Not looking back, eyes on the freeway, Bonnie and Clyde, a classic cliche. We're on the run, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free.
Okay, hello and welcome to the second in our law revision clinic from Tutor to You. I'm Dan, this is my colleague Gemma.
Hi everyone.
Okay, so this week we're going to be focusing on paper 2, and that's tort law. I can see already in the chat quite a bunch of you are discussing paper 1. So obviously we did that last week. We're going to focus on paper 2 and maybe discuss some things we've learned along the way from last week as well. So the way this will work is we've developed some questions, some frequently asked questions, and we've got some from earlier too. But we are going to focus on these questions from you today. So if you're here and you pop a question in the box, then like for example, Holly, where's Jim? Sadly, Jim isn't with us today. He's busy doing something else. So you're stuck with me and Gemma today. So please don't log off. This is still useful even if Jim isn't online. So yeah. So we are going to focus on the questions that are coming in regarding this paper today. So if you've got questions, please pop them in the box and we will go through them. Okay.
Okay, so firstly, shall we take a look at the advanced information just while we're waiting for some of those questions to come in? So the advanced information, I've recreated it there, what it states. So we've got law morality, civil courts and ADR, legal personnel, liability in negligence, we've got economic loss, we've got occupiers liability, and it does refer to the Occupiers Liability Act 1984, also vicarious liability and defences. However, the most important thing is that final, and I put it in bold in italic to make it stand out. It does state on that advanced information some questions may be answerable using more than one area of specified content, including ones not listed. Now, I think we have learnt from paper one that, the advanced information is just something to, give us some idea of what could be on this paper. It's not definitive of everything that will be on the paper. It does state that things not listed on the advanced information may still be on the paper. And we know that in the 30-mark questions, there's going to be a variety of different areas of the law that we're going to have to discuss there, a few different indicative content groups, 3 or 4 issues there, because it's our largest question. So, they could include Occupiers Liability Act 1984 in that, but it could also include the other Occupiers Liability Act not mentioned there. Okay, so make sure that you are revising everything, perhaps with a focus on this advanced information, but it could include areas not listed. Okay, so do bear that in mind, please, as we are revising and preparing for paper 2. Okay?
Indeed. So what you can see on the screen, all the advanced information. So we go back one slide, sorry. Just to a couple more questions there. So the content which isn't listed on there, as you can possibly tell, is the remedies. Okay, remedies are missing from there. Psychiatric harm or psychiatric injury is also missing from there, as is nuisance and Rallance and Fletcher torts. So I would definitely focus on those. I mean, you probably analyse the advanced information with your tutors and your teachers and come up with the idea that really there wasn't enough to fill a whole paper there. So it will be filled with the questions. Just, please listen. I think is the key there. We have got some questions coming in, haven't we? So we've got, I think, vicarious liability. I think that is a couple of questions coming up. I think is it Feelish and Katarina as well. So vicarious. Oh, that's an answer rather than a statement. I think a good answer. Vicarious liability has often come up in the past with economic loss, but I'm not suggesting that it would only ever come up that way, because of course an employee can commit negligence in many other ways, and negligence standard negligence being one of those. So be sure that it could come up with one of those things, but it could sit on its own. So if you think of all of these areas, sort of like those classic 10 markers, and you can sort of put them together as a jigsaw, can't you, as you go forward with your responses. So no, we won't always come up as a 30 marker. In the past, we've seen it as part of a theory question too, haven't we? So in that question 9.
Yeah. It could come up a part of it. Vicarious liability could come up in a 30 marker, but part of a question, part of the issue could come up in a 10 marker as well, couldn't it? Just looking at a particular area of vicarious liability. We have seen that before in other areas. So don't necessarily think it's always going to come up as a 30 marker. Okay.
Yes, indeed.
I've got another question there, or somebody stated something there. I think it's Reader T-M says, I'm struggling with timing. Now, that is a common issue, okay? I saw that question quite early on. Struggling with timing, I sympathise with you a lot, because that was me as an A-level student, so I know what that's like. Now, there are certain strategies if you are struggling with timing, okay? Obviously, your biggest marks are your last 2 questions in the paper, okay? So you might want to think about answering the paper back to front, okay? Starting with those big 30-mark questions, okay? Getting knowing that you've given those your best shots, okay, and you're not running out of time on those. So perhaps if you are struggling with timing, that might be something that might be best for you, doing your 30 markers and starting from back to front, so that if the worst comes to the worst, and you have run out of time, you're potentially only missing the 1 mark questions at the beginning with your multiple choices, instead of your big 30 mark questions at the end of the paper. So that might be a strategy. Perhaps have a go at that this week. Do a paper back to front and see if that does help you a little bit. Okay.
Absolutely, Matt McRoby. It seems that you have pretty much said the same things as Gemma's been saying there. You do work your way backwards. And Holly, yeah, good idea to make sure you've got some time at the end. I mean, we normally suggest around 40 minutes for those 30 mark questions, and because they do require some analysis and planning and some evaluation, in terms of extended application, of course. So yeah, do this. Yeah, so I mean that's a strategy. Another strategy I would suggest is sort of making maybe mini lists of the elements of each particular tort. So if you've got the duty, the first part of breach, the second part of breach, and first part of damage, second part of damage, and so on. And then you can sort of tick them off as you go along, knowing that you've dealt with them effectively. And it often helps you stick to the time that you know you should be doing. So if you've got sort of 5 elements, you sort of 2 or 3 minutes in each one, and no more. So that's what another thing I would do. Certainly get those plans jotted in the margins. We've got some other questions coming in then. So we've got structure of occupiers liability valuation. I'm not sure that's entirely on this paper. Sienna, I think. Evaluation of the occupiers liability, correct me if I'm wrong, Gemma, would tend to come up on the OCR paper.
Yeah, there is another session starting directly after this, which is looking at OCR papers. An evaluation could come up as a 20 marker on that, and there is advanced information telling you what's going to come up on that from OCR. So you might want to tune into the session after this one is finished. Okay.
Yeah, by all means, stick around for some general tips. But I think, the occupiers, we mostly focus, the evaluation for this course tends to be that extended application. So analysing those elements in any particular tort or any defence with the contentious elements. That's where the analysis comes through here. And indeed, on the last question for that 7 mark and then 9 mark, question 9 with the 15 mark question, that's where the analysis sits, but would not necessarily be in occupiers liability on its own. I mean, you might have to evaluate it when linking it with, for example, morality should be the question 9 this year, shouldn't it? So as we've seen, justice come up, fault came up already in question 9, paper 1. It looks like it's likely to be morality this time around. So it could be, how does occupiers liability link to morality? So for example, if you're looking at trespassers, then it could be that you sort of come from the idea of children being harmed, for example. That needs to be linked to, but that's really the only evaluation you're going to be doing on this paper.
We've got, well, you talked about occupiers liability out there. We've got a question from, I think it's Maya Jasmine. Do you think we will need to know OLA 1957 in full alongside the 84 Act?
Without a doubt.
Now, pardon?
Without a doubt.
Yeah, I was going to give a longer answer than that.
Yeah, absolutely.
I know that the advanced information does just refer to one of the acts, okay, but as I said at the beginning, I would be advising my students, and I think Dan's probably doing the same, to revise both of them, because the question could ask, in relation, it could be more focused on 84, but 57 could still be relevant. Okay.
Indeed,
so I would revise both of those together. Yes. Okay.
Yeah, perhaps they've sort of made one more obvious than another because more contentious elements need to be discussed, for example. So you focus your revision because you may need to analyse that particular one more. But of course, you may have somebody walks into a premises and starts off as a lawful visitor, but then becomes a trespasser, or there are 2 people in any one scenario. So you do need to be ultra careful and definitely prepare for that.
Absolutely. There's another question in there. Katerina Glido. I forgot to add the cases, even though in my annotations I wrote it. I think you're talking about paper 1 there. But of course, do make sure you are adding the cases in as you go through, okay? Looking back, making sure you've got the authorities to back up what you're saying, and you've got that variety of case law, not just case law, it could be statutes as well, couldn't it? Okay, to back up what you've written there. Some of you might have learned that idea of how identify the issues, describe it, explain and apply it, with authorities, etc. You might have learned different ways of doing that, but make sure that you are moving from that like AO1 knowledge to the AO2 application in your answers. Okay, so make sure that you are putting your cases or your statutes or your authorities in there. Okay.
Yeah, indeed. Going back, I mean, in terms of application, we definitely need to include those in application, extended application. There's 2/3 of your marks on the substantive elements of the law, and so yeah, linking to cases, we do need those. But what I would say as well is we need to make sure the law is explained clearly. Your examiners will look kindly if you've explained the law and it's clear that you know the law, even if you've forgotten those cases. So don't sit there panicking because you're forgetting one case name. Make sure the law's down. A golden rule, I think we had this question last week. You're aiming for sort of 3 to 4 cases per 10 marks as a minimum. And so don't sort of get bogged down. I mean, some of you will do more, some of you will be taught to do more. By all means, stick to what you've been taught. But this is sort of something we agreed upon last week in the last week's session, if you were there too.
We're getting loads of questions. I don't know if you're
We are
seeing
indeed.
these, Dan.
Yeah, so we've done one
Caparo,
already.
Robinson, aren't we? And you've seen all
Oh,
those.
goodness me.
Can
Yeah,
we? There's loads of them, all asking the
why do
same
we
thing.
use why do we use Caparo test? Okay, we don't use the Caparo test because it is no longer the test for duty of care. Okay, after Robinson, the test is an incremental one. So we look for a possible analogy if there's no direct precedent already. And it's very unlikely, isn't it, that they're going to give you a situation which is novel. And I know there was some kind of discussion where we used it for novel tests. And so you should probably use analogies more than anything else, I would suggest. Certainly that's something I told my students. And for doing various bits of work and what have you, Caparo test is no longer the same way. Gosh, you wouldn't have used that last week for theft, for dishonesty. I think we can confidently say that the law has moved on from that.
Yeah, that's the thing with the law, and why I like teaching it so much is that it changes all the time. What I'm teaching now is not the same that I was teaching 10 years ago. Okay, so yeah, and Robinson has changed it and said we are using, analogy, as Dan said, if there's a similar case, we use that. Okay, so we've got lots of authorities there that we use, and it saves time really as well, and we don't need to go through the Caparo and Dickman 3-part test for a duty of care in a road traffic accident, yeah, because we know that. Okay, we would only use it for those, as Dan said there, those novel cases.
And let me say, it's unlikely you're going to get some kind of novel case. It will be, we didn't write the exams, but we can confidently predict that there will be some sort of similar analogy. So it could even be, a manufacturer's made something negligently, or it could be a driver. And then we go to cases we know, like Nettleship and Weston, Donoghue and Stevenson, which will act as precedents for those types of situations. I mean, Caparo and Dickman, strangely enough, you may use it when you discuss economic loss. I mean, that it certainly developed the statement. So Caparo and Dickman for negligence is a no, but it's still good authority for economic loss and negligent misstatement. So be sure to look at it through that prism as opposed to negligence, I would say.
Yeah, because Robinson, what's the date of Robinson? It's been in a while, hasn't it?
2018, yeah. So we're talking 4 years. There's usually a grace period in terms of A-level law, and obviously a little more grace given the last couple of years, I suppose. But I think at this point, 4 years down the line, we can't really be using law that's 4 years out of date. I mean, back in 2012, we wouldn't have still used the old law of provocation, would we? And so we need to do that. I mean, you probably all very small children at that point, but there we go. So we got another question about law morality. I think we can confidently predict it's going to be morality, Gemma. In terms of the theory element for question 9, it doesn't appear to be any other possibility. The only other possibility is question 3. That could, on paper 3, it could be balancing conflicting interests or justice. On question 9, it seems to be a balance there, possibilities. But for this, certainly go by the advanced information. They were true to the word in terms of fault on paper 1, and it could predict morality would be paper 2. The only element for that is obviously you've got that 10-mark structure. I'm sure your teachers will have gone with you, the 10 marks on discussing that theory of law and morality, so discussing the different concepts. But then the 5 marks is linking to a particular element. Now, we've seen it in the past as generally tort, but it could be, like I said before, link it to occupiers liability, link it to negligence, and of course you go back to negligence, the tort negligence, and it obviously began by the neighbour test, so that kind of Christian ethos, if you like, and then that developed from the sense of morality from the Bible. So I suppose we've got a starting point for that, but it could be linked to any area of the law, and suppose that's what we need to point out.
Yeah, just talking about question 9, I don't know about you, Dan, but I think that's probably one of the most difficult questions on the paper. And I think something that students do get quite worried about, my students anyway.
Yeah,
And it's really key to break it down into that, 10 and 5 marks. You're going to get your
it
10
is.
marks for your knowledge on morality, okay? And
Yes,
I'm sure you've learned lots of different theories. You could reel off an essay on morality. So don't get too hung up about it. You've got 10 marks. I was telling my students, you've got 10 marks in the bag there, okay? For
absolutely same.
putting all your morality down there, okay? And then your 5 marks, if it is, I would say if it is, morality in relation to tort in general or negligence in general, that is easier question than we've seen in some other papers where it's narrowed down to morality in relation to vicarious liability. Okay,
Yeah, we've seen that in
but
the past. Yeah,
yeah, we have. But again, try and break that down again. Okay, break it down. Give a brief explanation of vicarious liability, what that is. Okay, and then try and relate morality to vicarious liability. But don't get flustered about it. I see some students who see the question and think, I don't know how morality relates to vicarious liability, and they just leave that question. Okay, or get too flustered. Don't get flustered. You've got 10 marks for just your base morality. Okay.
I mean, if you
And then
really
your
get
5
stuck,
marks.
yeah. Sorry, Gemma. If you really get stuck, then you've got your own sense of morality, so you can look at law for the prism of your own morality for that 5 mark question, and discuss elements of it which reflect your sense of morality. Is it right, for example, if it was vicarious liability, is it right that we put a burden on employers when they don't have a degree of control anymore, or is it right that we have it? So you've got to sort of look at the from your prism. If you really get stuck, that's what you should be doing there. Look at any area of the law that they do
Mm.
tell you, and make sure that you
Yeah,
do
but
look at that.
don't get foxed in the exam. You do have your 10 marks, 10 out of your 15 there, you know what you're writing on, okay, on
Yeah.
morality, okay? And then it's only your 5 marks for relating it to that concept in tort. So don't get flustered in the exam. And I have had some students who've just got massively flustered with it. Don't, okay? I know it's a bit of a different one, isn't it? I always think as well, where it falls in the paper, and it's asking for different skill as well. But do remember that 10 and 5 breakdown.
I can see there's a bit of panic going over this Robinson issue. Now, honestly, if you look
Excuse me.
anywhere online, you will find plenty of information about Caparo. I think if you go on YouTube, you'll find plenty of videos explaining it. You'll find articles everywhere. I get that textbooks are dated 2016, but you really do need to be using that. And I suppose at this point, it's unfortunate that you've been going through that element. And I think we've seen it as experienced examiners ourselves. People do still creep. It sort of creeps into some papers, but you do need to make sure you're using Robinson. So you've got plenty of time now between now and Monday in order to get this right. So I think we should make sure we're doing that.
There might be some
Rider TM,
are there some other tutor 2 videos as well? There might be some other revision blasts as
there
well
are
that are
indeed,
available on YouTube that
indeed.
will go over some of this as well. So do look back on those. All those are still available,
Yeah.
I'm sure, aren't they?
Yeah, so we have study streams and revision blasts. Now the study streams are more they've got more information on them. The revision blasts were pretty much games, live games, and what have you. So you can have a go with them, by all means. But the information will be on the law study streams. That's what you're looking for that. We've got a question from Ryder TM about private nuisance and Rounds and Fletcher. If we want to just address that, I think we have a little bit, but just to be clear, it was not in the information, the advanced information, but it's clear from paper 1 that we should, without doubt, be looking over that. So you will have been going through this in class or what have you, and you should be going over this, being able to absolutely, answer a 10-mark question on it. Be prepared for both of those. And indeed, question 9 is synoptic, isn't it? So synoptic just means it could come from any area of the course, and that morality issue could be linked to private nuisance or Rylands and Fletcher. So absolutely be sure to cover that in your revision. Yes. I think there was a few of them, wasn't there? Yeah, so we had, so duress wasn't on it in the past paper on the advanced information, but it came up, absolutely. So, yeah, absolutely. So, yeah, you need to revise it.
Yeah, I think we can't get too hung up on this advanced information, as you've probably seen from Monday's exam. Okay, and I think it's very key that it does say that other areas could come up as well. Okay, so
there's a fantastic
bear that in
question
mind.
in the event whistle. Sorry, in a second as well.
Go on, then. Sorry. Oh
No,
yes,
sorry.
I
So
saw this.
yeah, I saw
Yeah,
this before, and I thought I will forget it. So forgive me. But I think this is a really good question. Do
absolutely.
you want to take it though, Gemma?
Oh, right, okay. It's a
Sorry,
fantastic question for me to answer. No, that's fine. Okay, so indicative content groups. So a 30-mark question will have 3 or 4 indicative content groups in it, okay? And you do need to get coverage of those indicative content groups, really, okay? Now, bear in mind what I said before about, if you are running out of time and doing the paper back to front and starting with these 30-mark questions, to make sure you are getting coverage of those indicative content groups. And, it is a skill in itself, spotting those indicative content groups in the paper, okay? So spotting these, it is occupies liability, spotting these nuisance, spotting these, defences, etc., okay, and going through them. You do need to make sure that you are covering those different indicative content groups in your answer. I think that it is really key, because
Yeah. So
somebody
this
obviously
is it.
been looking there at somebody. Their needs obviously been looking at the mark schemes and them talking about, and examiners' reports as well, talking about, coverage of them to get in the highest bands of the grade. Okay, you do have to have all those indicative content groups in there.
Indeed, put simply, if we have 3, 3 or 4 content groups and you're missing one of them, and you did that across, 2 questions, you're losing a number of marks there. You put simply, you will be. There's no extra credit for getting one perfect when you miss a different one out. You need to make sure
Yeah.
you're covering all without a doubt.
Absolutely,
Uh,
yeah. Sorry, indicative content groups. So in a 30-mark question, if you look on mark schemes at the end, you will see they do say ICG, don't they, Dan? It
Indeed,
does say
ICG, and what they were expecting to be covered in that question,
yeah,
essentially. Now, this is why we say in those 30-mark questions, you should spend longer, because you do need time to read through and plan your answer as well. So I can see, even from the conversation today, conversation online, conversation with my own students, that people didn't do that, and people sort of thought one thing was in one paper, one was in another question, and in fact didn't come up. So spending time going through and what is the question answering. So in the paper on Monday, the indicative content could have been insanity, theft, robbery, for example. So they're the indicative content groups. It just means the area of the law, really.
yeah.
I suppose that's examiner speak, isn't it?
Yeah, sometimes some teachers will say, like, what are the 3 issues in this
Yes,
question? Yeah,
yes,
so it'd be,
absolutely,
nuisance, negligence, and a remedy. It's the issues that are coming up,
absolutely.
okay? And in the 30 marker, if you think there's only just one issue in there, look again, okay? Because there's more than
Absolutely.
that to get
Yeah.
your marks in.
I mean, if we think of, the classic 10 markers, if there's only 2 and you've only spotted 2, you need to be looking for further ones. Now, I suppose going back to an earlier question as well, sometimes some are less weighted. Okay, so a defense is not going to be as heavily weighted as a whole area of tort. So if you miss that indicative content out, it wouldn't impact as much, but you certainly should be looking for it. We've got a good question from Matt McRoby as well. I think if you aren't sure what the actual outcome could be, it'd be interesting to, I guess, see 2 teachers' perspectives on this one. So Matt McRoby, if you aren't sure what the actual outcome would be, I was always taught to say, like, if this is such and such, then they will be liable for X, Y, Z. If not, they'll be liable for something else. Okay. It is, on some occasions, be confident enough to sit on the fence, certainly when you're going through your application, because when you're going through your application, some issues may be more obvious than others in terms of being met in that scenario, and you may need to sit on the fence a bit before concluding at the end. Put it this way, if you've got a 10-mark question and you think it hasn't been satisfied by the second element of negligence, for example, then you won't have enough content to talk about to reach the top bands. So you've got to sit on the fence and discuss every element. And I think, Matt, that was more of a statement that I think Matt wants to join us in terms of giving advice rather. That was a question. Sort of read it wrong there. Thank you, Matt, for all your advice.
Yeah, I mean, you have got to cover all the outcomes, okay? You know, if you think that that's relevant, okay, you can't just stop halfway through if you think, you know, I've not got enough here to make an answer, okay? So do bear that in mind.
There's another question from I mean, there's a lot of M's and X's. I think it's someone called Molly
Yeah,
Glover. I think it's Molly Glover. I'm gonna use my code brain there.
yeah. For
So
that
for
one, for occupiers
Ola,
liability, that one.
yes.
Yeah.
Yeah, so should you mention the different sections, children working briefly, if they're not appropriate? The answer is no, absolutely not. You know, you're only going to pick the areas of the law that are relevant to the scenario. The same way in court, if you were trying to prove this particular tort, you're not going to bring in elements of the statute that are not relevant. So you wouldn't do it here either. Be careful
Yeah.
though to make sure you check that they actually don't exist. You know, um, and some people get mixed up between independent contractors and other elements, don't they? So we just need to make sure that you don't get mixed up between the elements, but certainly look to see whether they are there.
Yeah, if something isn't relevant, okay, so if there's no children in the scenario whatsoever, okay, then don't bring it in, because also
No,
I would really worry that you'd be wasting your time writing on that. You're not going to get marks for it, and you'd have wasted time which you could have spent better elsewhere as well, or you risk running out of time later on. So if there's no children in
indeed.
it, don't deal with it. If there's no workmen in it, just leave it out. Okay.
Just a point on workmen, though. Obviously, workmen have to take their own precautions, but independent contractors, a key there, they're essentially, that's defence, isn't it? And what the occupier is doing is shifting the blame. What that might lead to then is that person might be liable in negligence. So that's the way sort of they may link a question. And when we talk about indicative content groups before, that is a way in which you might spot one or two which don't normally obviously link. Legal enforcement and morality. Okay, NYLA Powerhouse, great name by the way. NYLA Powerhouse, can the legal enforcement of morality come up? Yes, if you think about that 10-mark question, the structure of the question is, what is morality? What is the law? What's the relationship between the two? What's the differences between the two? And how are moral values enforced legally? And that's sort of your 10-mark structure, isn't it? So I think it wouldn't come up on its own necessarily, but it would be part of what you need to discuss when you discuss law and morality for that question 9. Would you agree with that, Gemma?
Yeah, I think the other one you've got to be careful of is question 11, if we're talking about, you know, different structures of questions, because you're going to
Yes.
have, you know, it's a 30-mark question, isn't it? Okay, but it's really a 23 and 7-mark question, isn't it? When we think about it,
It is indeed. Yeah.
because it's got your 23 marks on your substantive area of the law, so occupies liability, vicarious liability, something like that. Okay,
Yeah.
and then you've got those 7 extra marks. Okay, which I always teach my students to do as like an add-on at the end. You know, your final.
Absolutely. The 7-mark add-on all
Yeah,
day.
it is. Yeah, your final piece. You know, leave a line and do that completely separately. And you know, it could be well, we've seen it on ELS before, haven't we?
We have indeed.
Issues there, which could be applicable here. You know, so but again, don't ignore that. Make sure, because that will be one of the indicative content groups.
Yeah, and I think with that structure of the question 11, you're naturally not then going to have 3 large application questions, are you? What you might have is, you know, 2 large application, for example, the tort of negligence and occupiers liability for the 10 marks. And then you're sort of going to have, I mean, roughly speaking at least, but then you're going to have a shorter part of that. So you might have a defense, you might have an area of the law which was not satisfied, so be careful there. So yeah, that the structure is much different in question 11, and before you get to the, as Gemma just described, the 7-mark add-on, which would normally be an area of ELS, and it will be loosely linked to the question, but not necessarily directly applicable. It's sort of like a tagged on, isn't it? Yeah.
Yeah, it is. It is, and sometimes I've seen them in past papers where they are quite loosely linked. Okay, that's why I'm saying do it separately. I would say to my students, leave a line and take a breath and then do that completely separately.
Without a doubt. There's a question from Debs as well. Debs with all the extra Zs. Do I get marked down if I don't remember theories for law and morality? When you say marked down, I think what you need to remember is what examiners will be doing is working from the ground up. They'll be trying to credit what you do discuss rather than mark you down. But I understand what you're saying. Will you get as many marks without theories? I suppose the answer is a short one. It's no, you won't. You do need to try to remember some theoretic elements. That's what it's in there for to do, to test some theory elements. So you do need, you've got a few days to go over that and make sure you're familiar with those. And again, there's plenty of materials available. I'm sure you come across those. But you should, without doubt, look at those series. Yeah, you need those for the top end marks at least.
I know we're coming towards the end, but there's just one question there. Reader TM, where will the ELS mention come up? There's quite a few mentioned in the advance. There is quite a few mentioned in the advance. So you're going to have,
there is,
ELS will be in your multiple choice as well, although I know the advanced information was not relating to that. It will be, you'll get a 5-mark question on some ELS topic, won't you? Okay. And as I said, as Dan said, we have seen a lot in question 11. The 7-mark element of that was ELS as well. Okay.
Indeed, yeah. So, I mean, in terms of the possible things which come up, I had to make a notice. We've got civil courts and other forms of dispute resolution. So there you've got the possibility of civil courts, civil appeals, ADR and tribunals within all of that context avenue, including advantages, disadvantages of those. So we need to be clear that any of that could come up, absolutely any of it. So we need to be sure there. You've got the role of the judge as well. So the role of the judge in civil cases is a possibility. It seems to be that those are the main two. So perhaps one of those could be a 5-mark question and one could be attached to that question 11.
Absolutely,
yeah.
Absolutely. What part of your question 11 could be, they don't want to deal with this in court, something about ADR or talking about judges or something there. So I think you've got two distinct areas of your ELS. One would be in a 5-mark and one would be a 7-mark of that question 11. Yeah.
Yeah, what we've often seen with that question 11, it would perhaps say something along the lines of assess the other methods if this person didn't want to go to court. And so it's not just about listing them. I mean, there is scope for that too. But what we need to be doing really there is looking at the possibility, the positives and negatives of using those things in that situation. Yeah. So that is normally how that, I mean, we've seen that word in that past before. I think we are.
Okay, so we've got to go. I know I could have gone on forever here, couldn't we?
Absolutely.
But there's so many brilliant questions there. But this is available for you to go back and review. It'll be available on YouTube very shortly. Okay, to go over. And remember as well, there's another one next week.
Next week, so that's on
paper
3, indeed.
Yes. On contract, yes. I should know because I'm doing that.
So it's you and I again, right? Excellent.
Yes, it is. Okay. So we hope to see you again then. But most importantly, good luck.
Absolutely. And if you do have any further questions, you can pop them in the comments and I'm sure they'll be addressed. So, yeah, thanks for watching and good luck with your exams, everybody.
Best of luck, everyone. Bye.